payments. The bank's going to keep all the money that you made, and they're not giving you any assurances that you're going to get a resolution. But it's an issue that you should be aware of. Loan modifications will affect your credit, and I think overwhelmingly in the industry, both people are saying that the HAMP modification has been a dismal failure. I did see a question here about, is robo-signing a real chance or a wishful hope? Let me say this. I think that a lot of that depends on whether you have the ability to bring the issue out in a way that the courts will deal with it. If the court has filed fraudulent documents and you were able to present it in a way that shows that, yes, Judge, in our firm we will use requests for admissions, which will make them admit that they did not do this appropriately. And if you know how the transactions were supposed to happen, the way that these assignments read simply are completely violative of the agreements that these banks made with themselves when they made these securitized trusts. So, yes, it is something that we have seen around the country. Banks, when they see that they're in trouble, will give a meaningful modification. Does it mean you get a free house? I think that that's wishful thinking. That it's not what we try to promote, because the odds of it, if there is a problem with the way the banks did their documentation, there is some entity that has the right to bring your loan and your foreclosure. That entity will not be the trust that is barred from giving meaningful modifications because of so many reasons, because of the way their agreements are structured. But it is certainly the best thing that we are seeing now to give us leverage. Look, if the bank can't prove their case, there are judges out there. I mean, it happened in Massachusetts, like just a few months ago. It was a huge victory for homeowners because these banks are now being held to a higher burden. Now let's talk about short sales. We have a few minutes. We're almost getting done here, but short sales are what the banks want. They would much prefer you just sell the house for them and give them a check. Why? Because the servicer gets to collect all their bogus fees right off the top, and the case is over. There's no more liability. There's no carrying costs. There's no realtor fees. It's just done. Something you guys to be pleased to be wary of is getting an approval on a short sale does not mean your troubles are over. It's important to look at what approval you're getting. If you do not have a waiver of deficiencies, then you are, you're going to have to deal with this debt still. I do not recommend to any of my clients to allow the short sale to go forward when there's only going to be a release of lien. I will go and force the bank into a negotiation, and I will either ask them sternly to waive any deficiency, or if I cannot get that agreement, I will ask them to accept a nominal amount for a contribution. Some people will pay more than a nominal amount depending on their ability to repay the full amount. But I have not seen any instance yet where a bank has told me, no, let the deal die, we're not willing to accept anything but the full payment on this loan. Your realtor will not tell you that. Your realtor gets paid when the deal closes. A transactional attorney gets paid when the deal closes. But if you have a litigator on your team, which I highly recommend you do, you will be able to continue the negotiation, and the deal's not dead as long as there's money on the table. What my firm does is we work with another law firm that handles the transactional side. The transactional guys go through loss mitigation. I start my court-ordered conciliation efforts, and we see who gets there first. It's a dual track. Some people, sometimes I find that I'm able to get the job done in a conciliation conference. Sometimes the conciliation conference isn't necessary because the transactional guys got it done. But it's important to try both directions. I have a question here about lenders willing to refinance these underwater mortgages. I have had some instances of private lenders, people with their own money to lend, who have made investments. I have successfully gotten a couple of people. I had one loan that was $360,000. The bank took $180,000. The problem is that the interest rate is very high, the costs are very high, and the company actually is out of business. There's not a lot of banks that are looking to pay for people whose homes are in foreclosure, although I personally believe it is one way we can really see a good results here. Finally, one of the best ways to get leverage is to be prepared to go to trial. Now, I know that some people think trial is a very scary experience. Well, eventually when you get there, the trial will happen, and what will happen is you will see the bank has their own burdens to prove. They're the plaintiff. I mean, I had a trial on Friday, and I watched this trial go down. I watched the whole morning, and bank after bank was called up and dismissed their case, or had their case dismissed because they didn't do what they were supposed to do. And ultimately that means the lawsuit has to start from scratch. And this person who's been in their homes for 2 or 3 years now gets to stay until the bank can start over and get back to a trial time. And if they get a second voluntary dismissal, that's going to be with prejudice, which means the case is over forever. So there is leverage to go to trial, and especially if you know that the bank's paperwork's not in order, or that the bank is going to have trouble with their witnesses, or a lot of my clients, we will hire expert witnesses that will go into the securitization of these loans, or whether they're predatory loans, or whether there was compliance with the origination laws of RESPA and TILA and HOPA. All of these things can be used in a court. Now, I think it's important to recognize that judges are hard pressed to give people free homes. I hear that over and over and over again. The judiciary has been a little bit hesitant to care so much that the banks aren't doing what they're supposed to do, because they think it's just as bad that the borrowers aren't paying. But that tide is turning as there's more information coming out about how these banks are operating, and some judges are making a stand about it. I had a question here about the taxes on the money for a short sale. We have a few minutes. I know it's 8:30 now, but I'll just try to answer that question. If it's your personal residence, your homestead property, the general rule is that you will not have to pay for what they call the 1099 forgiveness of debt. If it is investment property, you're supposed to. Now, I'm not a tax lawyer, and I recommend you get your own advice before you close in a short sale about the tax implications from a tax professional. However, I know that it is something you can try to negotiate, the amount of the 1099. These are things, everything is negotiable here. This is a lawsuit. It's not law. So I would like to thank everyone for joining me for this webinar. I hope that that you enjoyed it. I would appreciate if you can give me any comments before we close up here. If you enjoyed it, I'll be probably sending out a poll or a follow-up email to thank everyone and ask for a couple of your comments on how we can make this better. It's been my pleasure, and if anyone is in a situation where you've been served with a foreclosure, and either you have an attorney that you do not think is going to fight your case, or you don't have an attorney yet, please call my office, 305-358-7991, or give me come to my website, read my blog, get more informed, and we'll get through this together. So thank you very much. God bless and good luck.